I'm elder law attorney Jason Neufeld with the law firm Elder Needs Law. You can reach us at elderneedslaw.com. Today's question is, should I put my home into a revocable living trust or revocable trust? And the answer to the question is, I don't see why not. There's no drawback to doing it. In fact, my position is if you own real estate, you need a revocable living trust. Here's why. First is the Revocable Living Trust is a wonderful vehicle that will allow you, more specifically your children, to avoid having to go through the probate process. That's why most people choose to utilize a trust, is to avoid probate. When you only have your house in your name and you're relying on your will, a will is a one-way ticket to probate court, which means you have to hire another attorney, such as myself, to go guide that asset through the probate process so it could eventually get to your children, and they're going to have to pay a lawyer some amount of money to do that, and who wants that when we can avoid it with proper planning? But it's more than that. It's more than that. While you are alive, it makes sense to have your house in a revocable living trust. Well, first of all, there's no drawback to it in terms of it's still your homestead. You still get the homestead tax exemption, any other tax exemption that you may qualify for, you will still be able to obtain even though your house is in a trust. But if anything needs to be done with your house, it makes things more maneuverable in terms of if you're not able to do these things. For example, if it doesn't make sense for you to live in the house any longer because your care needs are too great, maybe it makes sense to sell your house. Well, if you lose your capacity, then whoever you designate as the trustee, the successor trustee after you, can help take care of that. Or maybe you want to keep the house, but it doesn't make sense for you to live there temporarily, and you go to an assisted living facility where your successor trustee can also be the one to help rent it out, to help pay for those sorts of things. Some people say, well, Jason, I am not worried about all that, and I just want to make sure that my kids don't have to go through the probate process, so I am just going to put my children on the deed of the house now, and then when I pass, they'll just own the house. And that is true. That will, A, avoid probate, and B, your children will not have to go to court in order to get the title to the house, assuming it's titled properly. But what they will lose out on is what's called the step-up in basis. Essentially, when you put your children's names on the house now, you get what's called a carryover tax basis, which means that when your children go to sell the house after you pass away, presumably, they will pay taxes on the difference between the cost of the value of the house when you purchased it, which may have been many, many years ago, and the value of the house when they eventually sell it. So you've got all these homes that, were purchased 30 years ago for $200,000 that are worth 600, 700, maybe more now. That's a lot of taxes your kids are going to have to pay. Whereas if they inherit the house through a revocable living trust, or will, by the way, but the revocable living trust is what allows them to avoid probate. They inherit the house through a revocable living trust, they get to take advantage of the step-up in basis, which means when they sell it, they'll only pay taxes on the difference in value from the time of your death to the time that they sell it, right? Not the date of purchase, but the value of the house from the date of your death versus when they wind up selling it. Typically a significant amount in tax savings. So if for no other reason, that is an excellent reason to put your house into a revocable living trust as opposed to having your kids on the deed now. Finally, what I like about using a trust is you can say what happens to the house after you pass away. For example, if you have more than one child and you put them on the deed, or maybe you utilize a ladybird deed to get them the house, which I have other videos on that. I'm not going to get into that now. But essentially, if when you pass away, the net effect is you have two or more remaining owners of the house, well, now your children are business partners, right? They have to agree on everything. They both have to sign the deed. They both have to sign a rental agreement. If one of them wants to hold the house hostage, they can do that. Whereas in a trust, you can spell out what you want to happen. You can say things like, upon my death, I want that house sold within a year and then the proceeds distributed equally among my children. boom, the trustee has to do that. Or I want to give child A the ability to buy out children B and C for fair market value, and we can talk about how we calculate fair market value in the trust. So the trust is you give your successor trustee an instruction manual on what you want to happen. They have to honor it. Whereas if your children just own the house outright by operation of law because they're on the deed, now they have to agree. Now they can both kind of argue with each other. And a revocable trust is a really nice way of avoiding family disputes, or at least making things very clear as to what's going to happen. There's a lot more I can say about this, but I think that gives you a lot of food for thought. If you own a house, you need a revocable living trust. Certainly there are other important estate planning documents we can talk about as well. If you'd like to have that conversation, please call us, set up a consultation, and thank you very much. If you like this video, please give it a thumbs up, please share it. Please subscribe to the channel. We're trying to get as much good information out into the public as possible. Thank you very much for watching.